Have you been wondering what the differences are between a will and a trust? Don't stress your mind anymore because I have tried to make it simple for you to understand in this rather short video. Let me first point out some similarities between a will and a trust to help you understand better. A will and a trust are similar because they are both viable estate planning devices. But it is best to seek advice from an expert to help you determine which will best serve your interests. Both can only be made by adults with testamentary capacity. That is, you must be of sound mind and fully understand the consequences of your action. Both must be written in clear language and properly executed. That is, duly signed as required by law. Please note that there are some special circumstances where a will need not be written down. Kindly follow me on my various social media platforms shown on the screen so that you will get notified when I drop a video on this and other insightful topics. Furthermore, a will and a trust are similar because they can be amended during the lifetime of the maker. Both documents must specifically name the beneficiaries of the properties. The properties to be distributed by a trustee under a trust settlement or an executor appointed under a will must be clearly described by the settlor or the testator respectively in a manner that makes it easy to locate the properties. So now, let me tell you a few differences between a will and a trust. The maker of a will is a testator, while the maker of a trust is called a settlor or a grantor. A will is testamentary in nature, that is, it takes effect after the death of the testator. But a trust is inter vivos, that is, it takes effect in the lifetime of the maker. Interestingly, a will can create a trust, which is a testamentary trust, but a trust cannot create a will. A will is a public document once it is read, but a trust is a private document and it creates confidentiality. This is also one of the advantages of a trust over a will. Executors are required for a will, while trustees are required for a trust settlement. Where a will is made, court supervision is mandatory during distribution of the properties, while a trust requires no court supervision whatsoever, as the trustee ensures seamless transfer of the properties directly to the beneficiaries. For clearer understanding, court supervision means that the executors appointed in the will must obtain letters of probate at the probate registry before they can validly distribute the estate of the deceased person. Assets in a will are subject to estate tax at 10% of the total asset value, while assets in a trust are not subject to estate tax but income tax. Don't get it twisted. A trust does not save you from taxes. It can only help you plan and manage your tax obligations. Now, please note that pension money from the RSA, that is retirement savings account, payable to the estate of a deceased person is not subject to 10% estate tax. A will, being a public document, once it has been read, is easily open to contest, while a trust can provide the settlor and beneficiaries with privacy and confidentiality. Now, this is one truth I would like to bring to your attention. There is significant rest and peace of mind in planning and putting your house in order at all times. Don't forget to check if your house and affairs are in order, because an unplanned estate is a potential chaos being nurtured by you today.